This is a current trends case brief presentation of the criminal case R.V. Magoon. The citation is R.V. Magoon, 2018, SCC 14. Facts. On November 14, 2011, 6-year-old Micah Jordan was murdered after spending the weekend with her father, Spencer Jordan, and her stepmother, Mary Eve Magoon. She was burned, severely beaten, and forced to run up and down the stairs as forms of punishment. As a result, she suffered damage to her internal organs and sustained at least 5 serious blows to the head before she eventually fell unconscious. It was only then that her father called the paramedics that brought her to the hospital, where she died the following day. 3 days prior to her death, Mr. Jordan texted Micah's biological mother asking that she stay the weekend, using the false excuse that he wanted company as Miss Magoon had left him. The truth was that he did not want the mother to see Micah's burn on her hand. Miss Magoon and Mr. Jordan were charged with first-degree murder and then convicted of second-degree murder at the trial. This was because while the judge rejected the couple's claims that she died from a single accidental fall, the judge also sustained that Micah had not been unlawfully confined in her father's house. Miss Magoon and Mr. Jordan appealed to the Court of Appeal of Alberta from their second-degree murder convictions, and the Crown appealed from their first-degree murder acquittals. The Court of Appeal dismissed the accused's appeals, but allowed the Crown's appeals, substituting their original conviction for first-degree murder. This was because the appeal judge found that the prior trial judge applied a narrow and incorrect test to determine unlawful confinement. After proving that Micah had indeed been unable to leave, Mr. Jordan and Miss Magoon were then liable for first-degree murder under Section 231(5) of the Criminal Code. The defendants then appealed to the Supreme Court of Canada. Issues. Does the killing of Micah Jordan constitute as first-degree murder? Rather, had Micah Jordan been unlawfully confined when she died? Decision. The Supreme Court of Canada dismissed their appeal. Rationale. As set out in the precedent R.V. Harbottle from 1993, the test that determines what constitutes first-degree murder states that the Crown must prove beyond a reasonable doubt that 1. The accused was guilty of the underlying crime of domination or of attempting to commit that crime. 2. The accused was guilty of the murder of the victim. 3. The accused participated in the murder in such a manner that he was a substantial cause of the death of the victim. 4. There was no intervening act of another which resulted in the accused no longer being substantially connected to the death of the victim. And 5. The crimes of domination and murder were part of the same transaction. The Crown proved elements 2, 3, and 4. The second element was proven by the medical evidence that revealed the extent of her internal bleeding from the blow her father delivered to her gut, as well as any of the 5 potentially fatal blows to her head. The Crown had therefore met its burden of proving causation for both Miss Magoon and Mr. Jordan. Elements 3 and 4 were proven by the fact that they had discussed the different ways they would punish Micah beforehand, and that neither of them tried to stop the other. They were also fully aware of the damage they were inflicting and the deterioration of Micah's state throughout the weekend. Yet, they refused to stop and only called for help when she was in complete cardiac and respiratory failure. This meant that, according to the Court of Queen's Bench of Alberta, it was only second-degree murder. The judge from the Court of Appeal of Alberta changed the original judgment of second-degree murder to first-degree murder, as she found that all of the elements from the R.V. Harbottle test had been met, including 1 and 5, which had originally been rejected. The judge deemed Micah unlawfully confined, as Mr. Jordan and Miss Magoon had no legal right to her care, and the only reason Micah's mother did not come and get her was because Mr. Jordan lied about his intentions and her state. With all 5 elements of the test satisfied, they were then convicted of first-degree murder. Analysis. Looking at the 5 elements of the R.V. Harbottle test, murder in the first degree must meet many provisions, and yet Mr. Jordan and Miss Magoon's actions thoroughly satisfied all of the conduct requirements for their conviction. This case is a brutal one, and Micah Jordan's death needed to be met with the proper justice, which I believe was done by the Court of Appeal of Alberta and the Supreme Court of Canada following suit. The Court of Queen's Bench of Alberta made an error in assuming that elements 1 and 5 of the test were not met, as it seemed clear to me from the case's description that Micah had been confined from the beginning. She trusted her father enough to pay him a visit, and yet she was confronted with unimaginable horrors and was betrayed in the most shocking way. The legal standard for proving unlawful confinement is the same for children as for adults, but in the case of a parent-child relationship, courts should keep in mind that children are inherently vulnerable and expect directions from their parents. I also believe that it was obvious enough that a 6-year-old would not have the requisite physical or mental strength to overpower her father and leave his house. The Court of Appeal of Alberta only deemed her unlawfully confined because of her father's deceptive text to her biological mother, but I think, considering the circumstances, that she had been unlawfully confined regardless, and that the Crown should never have had to appeal to the provincial court. Survey question. Do you agree that Micah Jordan had been unlawfully confined when she died?